as you know, is a senior lecturer in law at Coventry University, and his presentation is titled Pluralist Democracy, Rule of Law, and Judicial Independence, the Crucial Role of the ECJ.
Thank you again. So my presentation will be in line with my opening remarks. What I would like to do here is to offer an example in practical terms of how European Union institutions can support the rule of law and protect the safety of fundamental values, something that is partly not only theoretical. So, but before starting, we have, I think, to understand that there is a general misunderstanding of the role of the European Union. Many also colleagues told me the European Union is going too far, it's too politicized, would like to do political things, it started as an economic union. Now, I think this is based on a misunderstanding. The role of the European Union project, the real sense of its project is to assure peace, promote fundamental values, and improve the well-being of nations. So, the hard and painful lesson that we learned with the Brexit referendum is that we have lost track of this fundamental purpose. Although for practical reason, and only practical reason, the European Economic Community started operating as a regional organization, which merely aimed at integrating the economies of Europe. The plan, and this was in the DNA of the project, the plan for a political integration has always represented the integral part of the European project. So if you think that in other different ways, I think that there is a misunderstanding. So that's the first thing that we have to clarify. So this was clear in the minds of our visionary leaders who inspired the creation of the Union. In 1946, Winston Churchill advocated the establishment of the United States of Europe, urging Europeans to create a common family of justice, mercy, and freedom. Jean Monnet, the French political and economic advisor, publicly declared the countries of Europe are too small to guarantee their people the necessary prosperity and social development. And this was said before globalization. It was vision. The European states must constitute themselves into a federation. So it's not surprising that there is an intimate connection between the EU project and the ideas, the very concept of democracy and the rule of law. Since the Second World War, the European nations have worked to build constitutional and parliamentary systems which protect individuals and minorities from arbitrary power. We call them a pluralist democracies because they give citizens the right to be different and to criticize authority, to say what we want. And this is a privilege. In order to safeguard such democratic rights, any democracy has to establish a legal framework based on the rule of law, which as ancient Greece and Republican Romans taught, just the Republicans, not the imperial ones, consists of the idea that laws should be applied equally to all citizens. Now, in our continent, we have two fundamental international organizations that aim at protecting human rights, pluralist democracy, and the rule of law. One is the Council of Europe, and the other one is the European Union, as well as promoting awareness and encouraging the development of Europe's cultural identity and diversity. A role which we need today more than ever. As the Council of Europe has highlighted in the 2017 report on the state of democracy in Europe, nationalist and xenophobic parties have made gains in a growing number of countries, challenging elites and exploiting public anxieties over migration. In many European countries, populist political parties are damaging democracy by limiting debate, delegitimizing dissent, dismantling the rule of law, parliamentary authority, free trade and civil society, undermining individual human rights and minority protection, and challenging international checks on unrestrained state power. That is what the EU is supposed to do. The purpose of this presentation is to demonstrate how the European Union institution may serve as a bastion of democracy and the rule of law, where national institutions drift towards authoritarianism and national governments prove to be incapable of defending the very fundamental values on which our free societies are based. I would like to demonstrate, in other words, how the European Union can give full force to the four freedoms, movement of goods, services, capital, and people, that our national politicians struggle to deliver. In particular, I would like to focus on the role of the European Court of Justice in Luxembourg, which with a recent decision has affirmed that judicial independence, that is the judge's responsibility to deliver justice independently, making impartial decisions based solely on fact and law, is a fundamental principle that has to be safeguarded all over the European Union. What happened was that by law number 75/2014, the Portuguese legislature reduced the remuneration of a series of employees of the public sector, poor civil servants. As a result, the remuneration also of the judges of the Court of Auditors was reduced. In response, the Trade Union of Portuguese judges brought an administrative action arguing that the salary reduction infringed the principle of judicial independence enshrined not only in the Portuguese constitution but also in EU law. Under the second subparagraph of Article 91, in reality, the Treaty of the European Union, the judges and the advocates general of the Court of Justice and the judges of General Court shall be chosen from persons whose independence is beyond doubt. Again, the independence of the judiciary is enshrined in Article 47 of the Charter of Fundamental Rights of the European Union, which says that everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal previously established by law. So in 2016, the Portuguese Supreme Administrative Court submitted a request for a preliminary ruling to the European Court of Justice. According to the Portuguese Supreme Administrative Court, the discretion which the Portuguese state has in implementing the budget did not relieve it of its obligation to respect the general principles of EU law, which include judicial independence. Now, although in the judgment of the 27th February 2018, the European Court of Justice concluded that the salary reduction measure issued did not impair the independence of Portuguese judges because they were just temporary and because all the civil servants were subject to them, so there was not an attack to the judges and the salary reduction was not really significant. So these were the three reasons. But the judgment of the court is, I think, is incredibly landmark because it, in a way that is revolutionary, asserted that according to Article 2 of the Treaties of the European Union, the Union is founded on values such as the rule of law, which are common to the member state in a society in which justice prevails. And national courts and tribunals, in collaboration with the Court of Justice, fulfill their duty entrusted to them jointly all over Europe, not domestically, of ensuring that in interpretation and application of the treaties, the law is observed. So the principle of the effective judicial protection of individual rights, from the perspective of the court, is a general principle of EU law stemming from the constitutional traditions common to the member states, which has been enshrined in Article 6 and 13 of the European Convention on Human Rights, and then reaffirmed by Article 47 of the European Charter. And the existence of effective judicial review represents the essence of the rule of law. It follows, from the perspective of the court, that every member state must ensure that these courts are established by law and independent. Now, the concept of independence presupposes that the judicial bodies exercise this function wholly autonomously, without being subject to any hierarchical constraint or subordinated to external pressure, liable to impair the independent judgment of its members and to influence their decisions. Because the independence of national courts is essential for proper working of the EU judicial cooperation system, any attack on the independence of the judiciary of a single member state is an attack on the entire Union, and the European Court of Justice has the right to intervene. Now, this is a landmark decision, so the court is preparing the ground to rule on independence in other countries, and the probable candidate, I think 99%, is Poland, where the nationalist law and justice government has reduced the public broadcaster to a propaganda organ, packed the civil service with loyalists, purging the public administration, and made it illegal to accuse the Polish nation of complicity in the Holocaust. Specifically, it undermined the independence of the judiciary by starting the Constitutional Tribunal with its cronies. In a law of December 2017, the Polish Parliament has approved the government proposal to hand the ruling party effective control of the judicial appointments and the Supreme Court. This even if 76% of polls oppose the establishment of a politicized judiciary. The Council of Europe described this legislation as a grave threat that puts a serious risk in the independence of all parts of the Polish judiciary. Let me conclude. So whilst the European Commission, despite its role as a guardian of the EU treaties, often struggle to balance the defense of the rule of law with respect for democratically elected governments, the judges of Luxembourg proved to be not bound by such constraints. We have the privilege to live at a time where a supranational organization, the European Union, established on the rubble of our cities destroyed during the Second World War, watches over the application of the rule of law. But we have lost a lot to lose, especially in the aftermath of the Brexit referendum. And it is our responsibility to stand up for the EU project without taking it for granted. Thank you very much.